Supreme Court of Florida is now in session. Please be seated.
Okay. The next case on the docket and the last case on the docket is Phillips versus State. Whenever you're ready, counsel.
Thank you, Your Honor. May it please the court, my name is Frank Tassoni, and I have the privilege of representing Mr. Phillips in this particular case. I have difficulty in presenting what I think are the issues in this case, and I'll try and narrow them down. It was a rather lengthy opinion by the trial court, but what the trial court essentially did was make and I'm talking about the first issue presented, make a finding between two psychologists or individuals with a psychological background. One was Dr. Woe, spelled O-A-H-O-U, but pronounced Woe, and the other one was Dr. The other doctor called by the state. And the court went through a rather lengthy analysis. And
that's on the intellectual disability issue.
On the intellectual disability.
Why isn't that moot? Because we know this is going back for a new penalty phase, correct?
Yes, well, certainly can.
Well, if the state decides to proceed with that.
Correct.
Okay. So, but no longer a death sentence. Why wouldn't that be dealt with? Okay, you kind of, when you said it can, it may not even be an issue ever if the state decides not to proceed with it. Why would we decide that now when, as you just indicated, it may never be an issue and is not an issue right now?
Your Honor, Justice Kennedy, I sent probably 3 or 4 emails to 2 or 3 assistant state attorneys, telephone calls, some letters basically saying, I think this can be resolved even before the case may be returned for a hearing, but I'm trying to resolve it without further, I think it would be very costly if the state decided to pursue it. I don't.
Well, but that's, okay, whatever the state decides to do, the state decides to do, and then you can make your arguments there in those proceedings if they take place. But why bring that to us now? Why would we decide this issue that may never even need to be decided?
In our opinion and our position is the court made an incorrect decision. Now, could that be resolved at a later date?
But it's effectively gone away because it's going to be, it's a new day, a de novo proceeding.
If the state did decide to proceed, Justice Kennedy, then it would have to be relitigated. I mean, which is...
But that helps you, doesn't it?
Well, it would help whoever the attorney is who handles it, but I tried to resolve this. Getting a quick decision by the state was unsuccessful in doing so. Anyway, what Judge Cooper found, she found that Judge Pritchard was operating on I think she said an old formula. She found that pretty much everything that Dr. Woe did was done correctly. And then in her final line in the order, one of her final lines, she said specifically, the court finds defendant's deficit in adaptive functioning did not occur concurrently with significant sub-average general intellectual functioning. There's no mention of that factually, at least with any kind of specificity in the order, and I would submit, Your Honor, that the decision of the trial court was incorrect and that this court could send it back to the trial court, say make the correct decision, or whatever decision. Thank you.
Thank you. Counsel?
Chief Justice Labarga, members of the court, may it please the court, my name is Jennifer Donahue. I'm an assistant attorney general and I represent the state in this matter. This court should affirm the post-conviction court's denial of the appellant's intellectual disability claims because he failed to present clear and convincing evidence of intellectual disability. To your point, Justice Kennedy, it is unripe and moot at the same time. But since we're here, you have all the information that you need to make the decision in this case, that the appellant is not intellectually disabled. And we would ask that you do affirm the post-conviction court's order in this case that the appellant is not intellectually disabled. For prong one, significant sub-average general intellectual functioning, Dr. Woe tested the appellant in 2013, and he received a full-scale IQ score of 79, which demonstrates that he does not meet prong one of significant sub-average general.
I'm just a little confused. Issue one in your brief was that we should dismiss this,
Absolutely, Your Honor.
but now you're saying that we should decide it?
Well, Your Honor, there's public policy reasons for you to decide it at this point. It would give the state the ability to determine what step to take next. Say you were to say that he is intellectually disabled, obviously the state can't pursue the death penalty. However, as far as expediency,
Well, if you want us to decide the issue, advocacy that raises as your first issue on appeal that it needs to be dismissed would be an interesting way to go about that.
yes, Your Honor. I mean, generally, this is brought up pretrial and would come to you on direct appeal. So certainly you have all of the information you need to make the decision. It won't necessarily
But
be.
why wouldn't we just really think of that as an advisory opinion? I mean, I understand you think it would be a helpful advisory opinion from the state's perspective because you think you're going to win. But we're not in the business of giving advisory opinions about moot questions.
That is correct, Your
As you said, moot and unripe.
That's correct, Your Honor. But intellectual disability is kind of an interesting animal because your decision would be binding on trial court. You have all the information you need before you, and if this were to go back, you were to send it back without making a decision, the trial court's not going to rehear all of the evidence. She's going to go rely on the evidence that she already has before you.
But really, how does that fit with our jurisprudence that resentencing proceedings are de novo proceedings?
I'm not sure I understand your question, Your Honor.
Never mind then.
Okay. So certainly,
I guess your position is it would be law of the case. It would be established as factually as law of the case.
if you were to make a decision, yes, unless they were to present.
It would not prohibit, I mean, yeah, okay.
Unless they
It
were
wouldn't
to-
prohibit them to come in from a post-conviction proceeding and say, well, they didn't present all the evidence or sufficient evidence or that kind of thing.
And that would be under a newly discovered evidence theory of why they should get a chance to relitigate the issue. But it would be a law of the case, collateral estoppel type issue. So as to prong one, the appellant does not have significant sub-average general intellectual functioning. As to prong two, he does not have concurrent deficits in adaptive functioning. The appellant's best evidence of adaptive functioning issues was a Vineland test, which was performed by Dr. Woe. But as Dr. Pritchard for the state talked about, the Vineland test was very unreliable. We don't know at what time period the individual who was observing the appellant was making these observations, whether it was age 1, age 5, age 10, age 15. So she talks about the appellant not being able to say things such as mama and dada, and we have directly contradictory evidence in the record itself based on the appellant's confession, which was entered into the trial record, and a conversation that he had with his girlfriend at the time. Additionally, we have information from the sister who testified at trial that he and his sister lived alone together, that she had a debilitating disease, and essentially that the appellant was taking care of the sister. He would change her, he would wash her, he would fix dinner for her, he would give her medications. All of these things, not only is he taking care of himself, he's taking care of his sister. Certainly, he does not suffer from deficits in adaptive functioning. And as to the third prong, manifestation before age 18, he did have problems in school, but they were related to emotional handicap and ADHD issues. We have 3 tests prior to age 18. One was at age 6. he received a full-scale score of 80. One was almost at age 7, full-scale score of 89. And then there was a 68 at age 15, within 90 days of arriving at the Dozier School. And that test itself has indicia of unreliability. And certainly, intellectual disability is not something that comes and goes. It's something that would be pretty consistent throughout one's life. So the fact that we have an 80, an 89, and a 79 all cluster around each other, the 68 is not really reliable in comparison with the other data that we have. If there are no other questions, either this court should rule that the issue is moot and unripe, or should affirm the post-conviction court's denial of the intellectual disability claims. Thank you.
In rebuttal?
Unless any of the justices have any questions, I have no rebuttal.
I do have one question. I just, never mind. I'll reserve my comment. Thank you.
Okay, thank you for your arguments. The court's in recess.
All rise.